Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's stream, we turn our attention to Georgia, to the YSL case, a case that's basically been a disaster area since they brought it. We already had one mistrial, and now we have a judge recused because of reasons we're going to get into. This case has been just truly a disaster by the state of Georgia for any number of reasons that we could get into, but whatever, one step at a time. Let's get into the motion to recuse the judge, which was decided by a different judge, I believe. So we're going to get into the motion to recuse Judge Glanville. The case is before the court on the following issues. The defendant, motion to recuse the judge, chief judge. The motion to quash to show order or recuse Judge Glanville, and defendant's motion disqualify or recuse Judge Glanville from all further dealings. So all kinds of things going on in this case. Fun and exciting. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. We've seen some of that. It's been a thing. It's certainly been an interesting thing, to be sure. Having considered the recorded evidence and applicable case law, the court finds as follows. What do you have for us, court? These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County. It's always Fulton County, isn't it? Fannie Willis, just here to the cause over here. Alleging gang activity and associated crimes. Although there were 28 named defendants in the indictment, only 6 were being tried as of June the 7th. Is a massive conspiracy, according to the state, involving many interlays of people, and it's a nightmare prosecution, and whatever. The motions to recuse all arise from the same set of circumstances relating to the state's witness, Copeland. On June the 7th of 2024, the state intended to call Copeland to testify. Prior to his testimony, counsel for Copeland, John Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment rights. Cool. The judge brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Copeland. Judge Glanville specifically advised Copeland that if he invoked his Fifth Amendment and refused to testify, the state would ask Copeland to be held in contempt and jailed. He also advised that if asked, Judge Glanville will jail him for refusing to testify. Okay. So you can be compelled to be a witness if you get immunity, right? At least use and derivative use immunity, according to the U.S. Supreme Court, right? Immunity comes in 2 flavors: transactional immunity or use and derivative use immunity. So transactional immunity is we will never prosecute you for the crime. Use and derivative use immunity is we won't use your testimony against you and anything we learn from the testimony. So that is sufficient according to the Supreme Court, at least. And so that would be true, right? If they have given you immunity, then you're forced to testify because you have no exposure, because either way, what you say on the stand can't be used against you. So you have no exposure. So you aren't incriminating yourself. So that's the idea. Okay. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, he was asked to specify his age. Instead of answering, said, "I plead the Fifth." Judge Glanville excused the jury and then advised Copeland in open court that he was in contempt and ordered him jailed, at which time Judge Glanville told Copeland that he would revisit the willingness to testify. Okay, so far that sounds okay. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Copeland on Monday, and the court was adjourned for the day. So far, so good. On June the 10th of 2024 at approximately 10 a.m. or approximately 9 a.m., Judge Glanville met with counsel for the state, Adrena Love, and stand-in counsel for Copeland, Kayla Bumpus. Okay. The meeting took place in the judge's chambers. Stand-in counsel. Stand-in counsel. Okay. This sounds like a very, very weird thing, if I understand what they mean by stand-in counsel. So this isn't your attorney. This is an attorney that's been appointed for you It's like a secret attorney is usually what they mean by stand-in counsel, and maybe that's what they're talking about. The only time I've ever like heard of this being done is basically like if they think that the lawyer themselves is like corrupt, like bribed or something like that. So you have to advise the client of it, but you don't want to advise their attorney because they're the subject of an investigation. And so you bring in another attorney unknown to the defense attorney to stand in for the defendant so that their rights are preserved. So it's like the only time I've ever heard of this being done is when you're trying to go after the defense lawyer. And so, but those situations are super duper unheard of rare because, of every possible reason. But that's what, when they say stand-in counsel, that's what plugs into my mind. This is counsel that maybe before this second, the defendant didn't even know existed because they might have just been appointed just now by the court. So if that's what they mean by stand-in counsel, something has gone horribly, horribly wrong, right? So yeah, okay, fun times. Oh, they asked to cover for him. Oh, his attorney couldn't be there that day. Oh, it was just someone to stand in for him. Oh, okay. So it wasn't that nefarious. Oh, okay. All right. So because my mind went weird places when I read stand-in counsel. Oh, so it's just an attorney that the defense counsel asked to be there because they couldn't be there that day. Oh, okay. Never mind. Withdraw my comment. Okay. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendant did not participate in the meeting. Counsel for trial defendants, did not take place in the meeting and were not aware the meeting was taking place. So the lawyer for the witness is there, the state is there, but not the defense team. Okay, that's all right. The transcript reflects that Miss Love told the judge that she wanted the meeting to both impress upon Copeland the risk of refusing to testify and allowing Copeland to ask questions before he testified. Miss Love also expressed concerns to Glanville about Mr. Copeland's representation. Miss Bumpus, Miss Love, and Judge Glanville also discussed the scope and effect of Stan's grant of immunity. Okay, so far so good. Mr. Copeland was then brought to Judge Glanville's chambers where he spoke with and asked questions of the various people that were there. Okay. During the time, the state advised Copeland he could remain in custody until the conclusion of the trials of all the defendants in the case, not just the 6 on trial. Okay. Judge Glanville discussed the relative statute with Copeland and his rights and responsibilities after a grant of immunity. Copeland spoke privately with his counsel, Miss Bumpus, and then advised the court he would testify. Okay. After the meeting, and immediately, but why isn't the defense team there? Right? Why isn't the defense team there? That's really weird, right? The prosecution's there, but why isn't the defense team there? If they're there for no other purpose than to just observe, why aren't they there? Why aren't they in the room? It's kind of weird. The situations in which we allow ex parte, especially in a criminal proceeding, are somewhat narrow, as you might expect. So this seems a little odd. After the meeting and immediately before Copeland was brought out to testify, defendant Williams' lawyer, Brian Steele, avowed the court that they were aware of the in-chamber meeting that morning. Steele objected to the ex-parte meeting. I would too. And a lengthy colloquy between the lawyer and the judge in which the judge inquired about how they became aware. How I became aware is not the most operative problem right now. Mr. Steele declined to reveal the source of his information, which is work product. So, I don't think he has to disclose it. So there's that. And the judge held him in contempt, though Steele was allowed to remain in the courtroom on behalf of his client. Ultimately, Kenneth Copeland did testify on June the 10th and was later released from custody. Okay. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex-parte meeting. Actually, it's worse than that. The way the ex-parte meeting was written, it was written for anyone who might have knowledge. And I was like, am I covered by this ex-parte order because it was so broadly written? I don't know. Anyways, requiring everyone, at least at the ex-parte meeting, to appear to show cause why they should not be held in contempt for disclosing meeting about the ex-parte meeting to the defense counsel. Which, why would they not be able to? And if an ex parte is proper for whatever reason, notifying the other side after it is pretty typical. So was I not supposed to do that? Was I not supposed to tell them about the ex parte? I'm like, okay. An amended show cause order was later entered setting July 1st for an in-camera, which just means in-chamber, review of the transcript of the ex parte meeting. The first motion to recuse followed by DeMonte Kendrick. Mr. Kendrick's motion seeks to recuse the judge for his involvement in the allegedly improper and coercive ex parte meeting with the state. Yeah, you really shouldn't be doing that. On June the 14th of 2024, the judge denied the motion, because of course he did. The judge determined the recusal motion was timely, supported by affidavit, and on cursory review, contains assertions of fact to support the allegation of bias and partiality. However, the judge ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chamber meeting, well, there is a way to verify the veracity of it. You have the people who are there testify about it, assuming there's no transcript. There's a way to do it. The affidavit was legally insufficient, and the motion to recuse did not require referral to another judge. On June the 14th of 2024, Kayla Bumpus then filed a motion to quash, to show cause order, and or recuse judge from presiding over any contempt action resulting from the alleged disclosure of the ex parte meeting. On June 17, 2024, Jeffrey Williams filed a motion to recuse the judge. Divorced from its hyperbole, Ms. Williams' motion and supplement also seeks to recuse the judge because of his involvement in the ex parte meeting, to which Mr. Williams also alleges was improper and coercive. Mr. Williams' motion alleges both actual bias and the appearance of bias because the judge allegedly participated in an accusatory process, and when he met with Mr. Copeland and the judge, became embroiled in the controversy when he held Mr. Williams' lawyer in contempt. Preach. That lawyer is going to have no problem getting clients for the foreseeable future. So, because he stands by his client, man. So, good for him. On July the 1st of 2024, the day appointed for the parties to review a redacted transcript of the meeting. Ooh, redacted, exciting. The judge announced that he was releasing the entirety of the transcript and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Okay, I'm not sure judicial notice is necessarily proper in this situation. Judicial notice is basically a way to take notice of something that is beyond all controversy within the relevant jurisdiction. So you can just take notice of a fact that is true and undisputably true. So you don't necessarily need to have someone testify to it because it's just undisputably true. But I'm not sure anything that occurred at this hearing would necessarily fall into that category because I think there's some disputes. So I'm not sure you can take notice of the transcript. That's fine because the transcript was produced, but anything that's not on a transcript, I'm not so sure you can take official notice, which is what judicial notice is. I'm not sure you can do that, but okay, fine. Most of what the judge relayed was a coalition of record evidence about Recom's circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. You could say no. In addressing the circumstances of contempt against Mr. Steele, Judge Glanville explained that the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. But why is it secret, though? Why is it secret, though? Judge Glanville advised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for timeline security. The judge then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. I mean, there are some situations, but I'm not sure why this is one of them. Judge Glanville maintained that no one gained a tactical advantage as the result of the ex parte. That's not necessarily neither here nor there. You have a right to be present, whether or not it gains you an advantage or not. It can gain you a disadvantage. You still have a right to be present. So I don't know that matters either way. The judge also questioned defendants' right to be present at the ex parte meeting because the issue under discussion was between the state and the witness, who is represented by an attorney. After making this record, Judge Glanville announced the show cause hearing was canceled, and the recusal motion, what a shit show, and the recusal motions were being referred to consideration for another judge in accordance with law. The motions recused were then assigned to this court for consideration. What a shit show. All right. Motions to recuse are governed by a specific legal framework outlined in the rules. A party seeking recusal must file a timely motion, supported by affidavit clearly stating the facts and reason for belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias or in favor of a party or prejudice towards the moving party or systematic pattern of prejudicial conduct towards persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in this action. Bare conclusions and opinions are not legally sufficient to support the motion. That's fair enough because the judge is allowed to make rulings, even if they favor one side or the other, even if they favor strongly one side or the other, because as we've discussed, judgment is not the same thing as bias. So you need something a little bit more to show the bias. Like, for example, holding an ex parte meeting might be a good example of some problems. One such motion is filed is the duty of the judge to temporarily cease action on the matter and assess the timeliness and legal sufficiency of the facts. If the criteria are met, the motion is timely, supported by an affidavit, and the facts might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by the rule of relevant code that provides that judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. The standard is objective, from the perspective of a reasonable, fair-minded, impartial person. Yep, that's fair enough. If the motion to recuse satisfies the three criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. Okay. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or defamatory the judge might know or perceive the allegations to be. Okay. A judge cannot become actively involved in presenting evidence or argument against the motion seeking his recusal without that defense itself becoming a basis for recusal. Fair enough. A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His efforts at defending himself against the motion to recuse will inevitably create an appearance of partiality. One reason that is if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy which persists after the motion is denied. That makes sense. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by affidavit. In transferring the case to another judge for consideration, Judge Glanville necessarily determined the third criteria was satisfied. The recusal might be authorized if the facts alleged in the motion were assumed to be true. Therefore, Judge Glanville was required to refer the motion to reassignment and was prohibited from opposing it. It is worth noting the court generally agrees with Judge Glanville's assessment of the propriety of the ex parte meeting. Okay, so they think the ex parte meeting was okay under the rules. All right. While the meeting could have and perhaps should have taken place in the open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and the process of making a record on July the 1st, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Okay. While it might be appropriate for a judge to disclose information relevant to his potential recusal, such disclosure must be made in such a way that's objective, dispassionate, and non-argumentative as possible so the judge is not reasonably perceived as hostile or an advocate. In presenting his record as a recusal issue and ruling on the motion, Judge Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal. The court has no doubt that Judge Glanville can and would continue to preside fairly over this matter if recusal was denied, but the necessity of preserving the public confidence weighs in favor of excusing the judge. Well, fine, we get to save some face, and the judge is recused. Based on the foregoing, the motion to recuse the chief judge is granted. The motion to quash is denied as moot. The defendant's motion to recuse the judge from all proceedings is granted, and the clerk shall reassign this case. So the shit show continues, and I suppose we're going to continue the trial with a new judge who's now going to come in several months into the trial and now, try to carry the case forward. That's got to be super fun for that judge. Incidentally, that's just got to be all the fun, because this judge is not coming into like, a day or two or three that this judge somehow has to catch up on. This judge now has to catch up on months and months and months and months of proceedings in an attempt to provide a seamless transition. Good luck. Good luck to whatever judge gets this. This sounds like a nightmare. It sounds like a nightmare. So, yeah. So we'll see. We'll see. And yeah, the new judge may try to order a mistrial, arguably because of manifest necessity. Maybe because the judge has been replaced. So maybe we go back and redo jury selection, all 8 months of it or whatever. What an annoying shit show. What an annoying shit show this is. This case is bizarre world, man. This case is just bizarre. So we will get a new judge who somehow will have to try to catch up on all this, I guess. Do I think he'll force a new trial? I think someone's going to think about it real hard, because the judge, the judge being dismissed from the case could potentially qualify as manifest necessity. I'd have to actually dig into the case law, but it might qualify as manifest necessity that would allow for a retrial, and back to square one we go. So yeah. So that's all there is to that. They already assigned a new judge. I feel for that guy or woman. I feel for that person horribly. As a judge, I'd be like, nope. 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 That's okay. I'm good. There's no way I'm going to be able to pick this up this deep into it, Yeah. That's a lot, man. So I think the odds-on favorite are for a mistrial. The problem apparently was not the problem apparently, according to the court, was not the ex parte hearing. Apparently that was not the problem. The problem was the judge attempting to put additional things on the record and attempting to defend himself and all the rest of it. So that apparently was the problem. So, yeah. The new judge is Shakura Ingram. I'd be like, nope. Nope. I'd recuse myself. I'll find a reason. Any reason. I recuse myself. I'm good. I don't want this nightmare fuel. Yeah. So we'll see how it goes and see if this trial is actually going to continue persisting. I'm not sure how, but we'll see. So we'll see. All right, I guess I'm going to sign off for now. I don't think either Trump or Vance talked yet, no. Vance is an interesting choice. I don't really know very much about him, to be honest, other than he's a senator from Ohio and he's 39. And so, he's young. I don't really know very much about him. And he's a Yale law grad. With he was editor of his law review, Marine. So tough guy, smart guy. So no, I guess that's okay. I don't really know anything more. I just know his bio. 39-year-old Marine, Yale Law Review, editor of Yale Law Review, smart guy. So yeah. We'll see. We'll see how it turns out, I guess. I don't know. Don't really know. Didn't really have a strong favorite, so I got to, I don't know what to say. But we'll see how it goes. Anyways, I've been Uncivil Law Tulare, my friends. I hope all's well. Cheers, my friends, for now, and goodbye.